Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, March 19th, 2025. In this week's episode, she has been dubbed the evil stepmother after allegedly keeping her stepchild held captive for over 20 years. Plus, a woman stands trial for the fatal stabbing of her roommate in a high-profile slaying that went years without an arrest. But first, Bryan Kohberger's defense is again fighting to have the death penalty taken off the table as the trial for the University of Idaho slayings draws near. Today, we're joined by Terri Austin, a former trial attorney and legal analyst you can catch on ABC, CBS, CNN, and many other outlets. Terri, welcome back.
Thank you. It's so good to be here, Josh.
Oh, I've been looking forward to this. It's been too long. How have you been?
It has. I've been well. Thank you. Doing well. I'm so happy to be appearing on your show.
Oh, well, thank you so much. And I'm so happy that you are, because I know that you follow these cases closely, and I always love hearing your insights. So why don't we just jump right in to our first case out of Moscow, Idaho, where court documents reveal new information related to the University of Idaho slayings as defense attorneys for Bryan Kohberger maneuver to get the death penalty off the table. Kohberger is charged with 4 counts of murder for the stabbing deaths of Madison Mogen, Kaylee Gonzalez, Zaina Kernodle, and Ethan Chapin, whose deaths shocked the nation after they were brutally killed in their off-campus home. Prosecutors are seeking the death penalty against Kohberger. However, his lawyers are arguing against the punishment, claiming that in a recent filing, Kohberger's autism diagnosis should preclude the man from the ultimate penalty, in a move that could set a new legal precedent. Federally, Atkins versus Virginia prohibits the execution of criminals with intellectual disabilities. However, states are allowed to decide which disabilities ultimately qualify. Also worth noting that autism is considered a developmental disability rather than an intellectual disability, so excluding the death penalty ahead of trial will be an uphill battle. New information has also come to light after the release of text messages exchanged between the surviving roommates, as well as the 911 call made after the fatal stabbings. These communications reveal the fear felt by 2 of the roommates after seeing a stranger in the house that night of the slayings, and the conversation with dispatch when they realized that the victims had taken their final breaths. Kohberger's trial is currently scheduled for August, and we will be watching it closely. Terri, first, we went, because of the gag orders in place and because of the kind of strict, attention put on this case and not releasing much information, we went a long time without getting new evidence. But now we have this dump of evidence with the 911 call and the transcript and the text messages back and forth between the roommates. And for the longest time, there was a lot of what I feel is unfair criticism of the surviving roommates' reactions that evening, because they did not immediately call 911 when they saw someone in the home. They only called hours later. It was nearly noon the next day before they called 911, and they didn't even realize that a murder had taken place. After seeing the text message exchanges and the 911 call, what is your reaction to all of this? What do you make of the way that the surviving roommates reacted?
Well, I think listening to the call, the first thing I'll say about that is it puts you back in that time and at that place. And clearly the roommates were confused and they didn't know exactly what had occurred. One thought that she saw someone walk by in a mask. The other one said that, they got together, they fell asleep, and the next day they went upstairs and another person came in and they realized that there was something amiss and that one wasn't moving. So, it was really clear that there was a lot of confusion. And I also think these are young women. They are in college. There might have been some involvement with being in a position where, all your faculties aren't there. Perhaps they had alcohol or other things that were going on. And so, you can't say what you might have done in that position. The other argument is, well, something was wrong. Why didn't they call? And why didn't they do something more? You have to think about it, though, Josh. Even if they had done something else, it does seem as though the way this crime occurred, the extent of the injuries, there's not much that could have been done. It's a horrible situation. Every time I think about it, I think about those 4 victims and the fear that they must have had, especially when you hear about what was said, that crying was heard, that there was some audio of a dog barking, that one person might have said, oh, well, I'll help you with that. Was that the person who was the killer? Was that Bryan Kohberger? All of that is just very frightening. And hearing all these new details in the 911 call, hearing it in the emails or texts that were exchanged is really, I think, making everybody think about what we're going to hear at trial and what actually occurred on that horrific day.
No, you're absolutely right. There's still so much for us to learn at trial. Like I said in my opening remarks here, they've just kept so much information from the public, and you can understand their concerns, but at the same time, it does cause people who've been watching this case closely to kind of have their imaginations and conspiracy theories run wild. But I couldn't agree with you more. I think too, as adults, many years removed from college, I think fair to say for both of us, it's unfair for us to say, well, I wouldn't react this way. They're young. They're finding themselves in a position they've never been in before. And even to add to that, I think there's a natural, and I'm curious to hear your thoughts. I think there's a natural instinct that we don't assume the most horrific when something is happening, that we hear a bump in the night and our reaction isn't immediately to call 911 and grab a baseball bat or a gun or something, that we kind of hope that it's just something that we're imagining or that it isn't as bad as we think it might be. And I wonder if that played a role in all of this, that they're just not assuming that what took place was a quadruple homicide in the other room.
That's exactly right. It's interesting you say you hear a bump in the night, because that was the example that came to my mind. When I hear a bump in the night, I think, oh, okay, that's just, I don't have a dog or a cat, but I think that's just a bird outside or something. And I don't assume the worst. I don't assume that somebody's coming in to do something untoward. And I'm certain that that's the last thing that they thought about. And remember, this was a home where a lot of people came in and out. They had parties. They had a lot of social gatherings, and it could have just been someone leaving. Maybe it was a creepy person, but it wasn't anything in their minds that could have led to something like this. Clearly, had they thought something like that was going on, they would have done something. They would have called 911. There's no reason to think they would have hid it if they had, known that there was something going on. Clearly, they cared about each other. These are roommates who are very close. You see them in all the pictures together, the 2 girls who were together all the time, the 2 who were dating. The fact is they were really all very close, and there's no reason to think that any of the roommates, or for that matter, anyone else had anything bad to say against any of them. When you look at what the parents have said, when you look at what friends have said, everyone says each and every one of those individuals who were the victims of this horrible crime were people who were giving back to the community. They were friendly. They always had a smile on their face. And when you see the photos, that's exactly what you think. You think they don't have a care in the world. They're dancing. Ethan had 2 twin sisters, and apparently the night before they had been together and dancing, and fortunately it was a positive memory that they now have. But the fact is, these were really happy students going to college, about to graduate, doing things that, college students do. And I don't think that there's any reason any of these roommates would have to not do as much as they possibly can. And I think it was a situation where they thought the best and just didn't realize what was going on, and until they did. And when they did, it was just, their worst nightmare, frankly.
Yeah. Yeah. No, I agree. And I think you make an excellent point too, that it's not just their age that makes their living condition different. It's that house they were living in is not typical. It was, been described many times as a party house where people are kind of in and out. And I imagine hearing someone leaving or coming in at very odd hours in the middle of the night or early morning is not entirely unheard of in that house. And so may not have raised as many alarm bells as it would with you or I. And at the end of the day, it's, I think, something they've suffered so much and gone through so much trauma. I hate to see them being then further criticized online. Putting that aside for a moment, let's move on to this new argument being raised by the defense on the death penalty. And I don't want to get into the kind of the politics of the death penalty. I know some people feel very strongly it should never be applied. Others feel strongly it should be. What do you make, though, of this kind of unique argument that it should be excluded in this case because he has been, and I don't know if we're going to hear from doctors or if this is something he had been diagnosed with previously, but he has, they're apparently now describing him as having autism, and that should somehow disqualify him from the death penalty.
I think it's a very interesting argument, but I think it is a stretch. You have to recall the defense has tried repeatedly to get the death penalty off of the table, understandably. And they've made arguments that it is beyond the standards of decency right now, as far as, the world is concerned, and that it's cruel and unusual for a defendant to have to wait for the actual execution of the death penalty. Those arguments failed. And you also have to remember, we're in Idaho, and there is no insanity defense in Idaho. So it's one of those states that takes this very seriously. You can't argue insanity here. You have to be able to say that you didn't have the mens rea, you didn't have the intent to actually commit this crime. So with that as a backdrop, we're seeing them now talk about this autism and that he's on the spectrum, and that perhaps that for that reason, the death penalty should be taken off of the table. I don't think that that is going to work. I think when you look at the case law here, the Supreme Court has actually held, and this is, one of the cases that I think people have been looking at, that in order for a defendant to be sentenced to death, you would have to have a significant impairment, an intellectual impairment, not a, disability that is developmental. And the CDC has actually defined autism as a developmental disability. And so because of that, I think it's going to be very hard to say that he didn't have the intent. And if you look at his affect, if you look at him, he's educated. I mean, he's got a college degree, he's got a master's degree, he's a smart man, he studied criminology. The case that the Supreme Court argued, the Atkins case, when they argued that case, or they heard the oral arguments, that case had to do with Atkins and this other gentleman, William Jones, and they together kidnapped someone, took him to a bank, made him take out money, then took him to a desolate place and shot him 8 times. And there were 2 people who testified in that case. One was Jones, one was Atkins, and they testified against each other. And Jones was a good witness, Atkins not as much. And there was some testimony that, he had some mental illness and that he had this incapacity, this intellectual disability. And because of that, the Supreme Court said, he is not someone who should be put to death, and that under the standards of our law here, that type of person who isn't able to make decisions and to have that sort of mens rea should not be put to death. I think this is a very different case. And if we see evidence that he has planned this, that it was premeditated, that he intended to kill them, I don't think we're going to get any sort of defense where that death penalty is dropped, at least not at this point. I mean, obviously, down the line, if he's found guilty and if the death penalty is still on the table, they can argue that, they're mitigating, aggravating factors and circumstances, and maybe he shouldn't be put to death based on how those come out into the trial. But right now, I think the judge is probably going to keep the death penalty on the table. And I'll add this. I think they're arguing so hard right now to get it off the table because that will put the defense in a much better place. If ever there's a plea deal, it would start with that off the table. And so I think they're trying very hard to get that done.
Yeah, I think you're absolutely right. You make the point that there's a difference between saying that some sort of condition or diagnosis is disqualifying from the death penalty and whether or not it could be used to argue to the jurors why it shouldn't be applied in this case. And I think that initial hurdle of whether or not it's disqualifying is going to be a more difficult battle for his defense than arguing, as you said, more of a mitigating factor as to why they shouldn't apply it in this case to this particular defendant. And to kind of further add to your point too, autism as a diagnosis is not it's been described in a way that it's not. There's varying degrees. In other words, they even talk about it being on a spectrum. So there's he obviously, if he was diagnosed with that, like you said, he's a high functioning person. He's going to get his doctorate for in that takes a person who has their wits about them to do that. And according to the allegations, this was not a spur of the moment flash of impulsivity type of crime. There was a lot of planning, preparation, and cover up in this, if everything that we're hearing from the prosecution can be proven true. So I think I agree with you. I think the court will agree with you that they're going to make their arguments and they're going after it as hard as they can. But I don't know if this one's going to actually carry the day. But we will continue to follow it. It's a case that seems to have developments every single week as we continue to march forward towards that approaching trial date.
I remember that exciting moment when we got my son his first bank account. It was really, really exciting. And I think it really set him up to become a good saver as an adult. So today's episode is sponsored by Acorns Early. Acorns Early is a smart money app and debit card for kids that helps them learn the value of money. Acorns Early Chores Tracker teaches kids that hard work pays off. Just set up chores in the app, set a payment amount, and then tick the chore off when it's done. Acorns Early also lets parents pay allowances automatically, so there's no more rummaging around for cash. Kids can spend what they earn with their very own debit card, and they'll even get to choose from more than 35 customizable card designs. Plus, parents can keep track of where and when their kids are spending, get real-time spending notifications, set spending limits, and more. Helping our kids understand saving and the value of money isn't easy. Acorn Early gives parents easy-to-use tools to help teach your kids without overcomplicating things. Plus, it's a fun way to incentivize them to save money and plan for what they want to buy. Ready to help your kids learn the value of money? Just head to acornsearly.com/truecrime or download the Acorns Early app to get started. Sign up now and your first month is on us. T&Cs apply, monthly subscription fee starting from $5 per month unless canceled.
Let's move to Waterbury, Connecticut, where a woman is facing shocking allegations after a fire at her residence allegedly revealed a victim who was held captive for more than 20 years. Kimberly Sullivan faces a number of charges, including assault, kidnapping, and cruelty to persons for the alleged detainment of her stepson. The alleged victim, who claims he started the blaze in a desperate attempt at freedom, is now 32 years of age, and reports indicate he weighed just 68 pounds when first responders discovered him at the scene of the fire. Sullivan was investigated by the State Department of Children and Families back in 2005 when the child was just 11 after complaints from administrators that the child was constantly malnourished. However, the agency couldn't find sufficient evidence of abuse, but the child was later pulled from school and largely unseen since then. Sullivan maintains that the alleged victim's upbringing was regimented by his father and Sullivan's late husband, Craig Sullivan. The media dubbed evil stepmother maintains her innocence in the case and is currently free on a $300,000 bail bond. Terri, I don't know where to begin on this one, but honestly, the more I think about it, the more I'm incensed by the idea of how did this go on for so long without someone knowing or alerting authorities or the authorities themselves getting involved. I mean, who dropped the ball here? How possibly could a child be investigated for being malnourished and they don't stop by again for another 10 plus years and that child's never at school? Explain how something like this could take place.
It's almost inexplicable, if you ask me, and you are asking me. And I have a hard time thinking about how, first of all, logistically, how this could have happened. As an adult in the later years, obviously as a child, you are with your caretaker, and this is his stepmother, and you're not going to necessarily run away from home, and you're going to stay in the home. But once you get to a certain age, at the age of 11, where most of this began to occur, you would think that you could get away logistically. You would think that if you went outside to do chores, which apparently he had to do, he had to wash the car or he had to clean the house. If you did those things, that you would be able to escape. But one of the things that has been reported is he was afraid. And you have to think about the mindset of someone who is being held captive. He was afraid. She apparently had a gun in the house. She apparently threatened him and said, look, if you think it's bad now, you try to get out and it will be even worse. So, it's the kind of thing where even though logistically he could have made a move, in his own mind, he didn't think he was able to do it. And the fact that he set this fire, it got to a point for him where he was going to get out no matter what, even if it burned the house down, even if it could have caused his own death. He was that desperate. And if you listen to some of the statements that were made about his condition, he was literally dying. I mean, with that low weight and with, the percentage that he had of body mass, he could have died. And so he was quite desperate at that time. Now, when you talk about the system and you look at what happened around him, they all failed. Even though I've listened to recordings of the principal of Barnard School at that time, and this is an elementary school, K through 12, I think it was. He said he called over 20 times. And okay, you called over 20 times. Is there something else you could have done? And I'm not blaming that person individually because there were neighbors, there are friends, there are people surrounding this young man who could have done something more. There were 2 incidents where the police in 2005 actually went to the home and they reported to the children's services that everything was fine, that the child was okay. Well, in 2005, he probably was emaciated then. And if not, maybe they should have investigated a little bit more, questioned him some more, questioned him outside the presence of the mother. Now, I don't know if those things were done, but the second time the police went to the home, they went because actually she was making complaints. The stepmother was making complaints that the school was calling too much. And ultimately, that was dropped. So the problem here is that ACS destroyed any records if they don't find that there's any validity to the claim. And So we won't even be able to investigate those records. So it's a very difficult situation. And in my opinion, there were many missed opportunities here. And I think the entire community should have responded better. And I think that she should have been held to a higher standard, obviously. And frankly, I'm grateful that he was able to think of a way to get out. He knew if he set that fire, the police department would come. He knew that someone else was going to notice what was going on. And it was, I think, a last desperate attempt to get the attention of someone. And so, yeah, it's hard to imagine that someone could be behind closed doors for 2 decades and not be able to get out. But we've seen other cases where people have been locked in. And remember, there were locks on these doors. And so perhaps he wasn't able to get out. And in his state, in his emaciated state, it might have been even more difficult for him to think about getting out.
Yeah. Listen, I mean, there's no one to blame for this but Kimberly Sullivan, right? I mean, I think we all agree that she is if everything is true, these are still allegations, but if everything is true, she is the evildoer here. But the fact that, and I'm so frustrated by this, the fact that the system did seem to fail this young man, that the neighbors, the principals, whoever else should have had some, beyond curiosity as to what was going on, failed him. Even his, like you point out, even the fact that it's gone on so long that he didn't make other attempts to alert people or escape. All of that, she's still the one, the person responsible for all of this. But do all those issues create some sort of defense for her? In other words, can she point to the fact that he didn't try to run off, or the fact that child services did stop by and the police did stop by and no one had a problem with any of this until years later, all of a sudden now they're trying to reconstruct this as her holding him captive. Do you see where I'm going there?
I see where you're going, and I think the defense sees where you're going, and I think that's exactly where they will go. They are trying to say that she didn't think anything was wrong, that, he could have left at any time, that just because there's a latch on a door, it's just a latch on a door. It doesn't mean anything. And so I think they're going to try to paint a picture of everything is well, there's nothing wrong here. He's, in his room most of the time, and she didn't mistreat him. She didn't beat him. It doesn't explain to me, though, how, she could not recognize his feeble condition. She didn't take him to the doctor. She didn't take him to the dentist. She didn't ensure, and as his guardian, she's supposed to ensure his well-being. I think they're going to probably try to argue, look, he was homeschooled, he had books, he read the dictionary, so she was taking care of his mental health as well. But I don't think at the end of the day that is going to hold up. And the very reason it's not going to hold up is because his condition was so bad. When they found him, yes, he was laying on the floor partially intentionally because he wanted them to come and get him so they would know that he was ill. But when they looked at him, when they actually observed him when he was in the hospital, they had to carry him into the ambulance. And it wasn't really because, based on what I've seen so far, of anything that happened in the fire, while he might have had some smoke inhalation, et cetera. It was because of his condition. And he decided, I'm going to lay down here. They're going to see me. They're going to hear me. They're going to understand what's going on here. And he said right out when he was leaving that, I set that fire. I set that fire because I wanted you to come get me. And wow. I think when someone is that desperate, you have to believe that this woman was an evil person, that this woman did not do, her guardian duties to take care of. And arguing that this is what the father who has now passed wanted makes no sense. This is a human condition that anybody should have recognized.
Yeah. God, what a tragic case. What a fascinating case. We are going to be following it closely because I really do want to see how this shapes out. I hope that justice is done. And you're right. Thank God he finally figured out a way to get himself proper attention and help. Let's move on to our final case, which is out of Grand Forks, North Dakota, where after multiple objections and a failed motion to dismiss, trial proceedings will move forward for a woman charged with the murder of her roommate. Nichole Rice faces felony murder for the stabbing death of Anita Knutson, who was found dead in their apartment back in 2007. The case made national headlines, but went cold for years after Knutson's father discovered her body when no one heard from the woman. Despite no evidence of theft and suspicions that the murder was likely perpetrated by someone with access to Knutson's apartment, Rice wasn't arrested until 2022. Friends of the two noted that the pair's relationship was strained, with Rice wanting Knutson out of the apartment by any means necessary. Rice also gave varying accounts of her whereabouts at the time of the killing, according to police, who say that she also told an old boyfriend she was responsible in the death. In a flurry of motions during jury selection, Rice's defense cited alleged Brady violations made by the state and sought a dismissal of the case. However, these issues were all rejected by the judge, who ruled that the trial would move forward with testimony underway by the time you are listening to this. Terri, Rice's defense claimed that the state withheld information regarding an interview with an alternate suspect. However, it was ultimately ruled that the interview was not exculpatory for Rice. Explain to us what is a Brady violation? What does the defense have to prove in order to have a judge find that there was a Brady violation? And then what does the judge do?
So in order to prove a Brady violation, the defense has to do two things. The first thing is that there was material evidence and it was withheld, and that evidence was exculpatory, meaning that it would have helped the defense. And, here it's really easy to determine that first instance, that evidence that was withheld. It has to be material, but that it was withheld. All you have to do is get the communications between the parties. Was it withheld? This interview that supposedly happened with the other individual who was a suspect, was that withheld? And when did the prosecution know about it? And, obviously, if the prosecution did the interview, they would know about it, or whether it was the police interview or whomever interviewed this witness, this potential suspect, that should have been turned over if, in fact, there was something that was said there that would have led, and the defense is claiming, look, no probable cause as far as Rice is concerned, because this other person was someone who could have been implicated, and our defendant is not implicated here. So, for the judge, I think has already determined that nothing wrong was done here, and that it wasn't a Brady violation. And so it does appear to me that things are going to move forward. So it's interesting. Brady violations are very, very serious. If you recall in the Alec Baldwin case, you can have a whole case dismissed. And at the end of the day, that's exactly why that case was dismissed against him, because there was evidence that the prosecution withheld regarding the actual bullets that were at the scene. And the judge was furious and just dismissed the case right out. I was watching it live, and It was really a moment. I don't know if you saw that live, but it was a moment that I will never forget. And if in fact it was a violation here, then there could be some serious penalties. But, it doesn't look like at the moment that there were violations. Perhaps the defense wasn't able to say we didn't get it or we didn't have an opportunity to see it. And based on what was said during that recording, the judge seems to think that it's not exculpatory. So a Brady violation is very serious if the prosecution actually has done that, but it doesn't seem like it's reached that level, at least not yet.
Yeah. That's a good way of dovetailing into my next question, because it looks like what the defense is going to attempt to do here is present some sort of alternative suspect, or where I practice what we would call the concept of third-party culpability, What are the legal challenges to that? Because a defense can't just say, hey, by the way, we think this guy's good for it. What do they have to prove to the court to allow for that kind of a defense?
Well, I think, I actually listened to the openings for this, which is right in process, as I believe. And, one of the things they're claiming is that their client had nothing to do with this. Their client wasn't around, that there were other suspects, and, that these other suspects were people who had access to the apartment. And so you're going to see in the case that it had nothing to do with the defendant. Now, whether or not that is what the evidence shows is still in question, but the defense will be able to cross-examine any of the witnesses that the prosecution puts on that stand to determine whether or not the police accurately investigated, whether or not there were other suspects, whether or not people had tried to get into the apartment beforehand. And if they're able to do that, they can argue to that jury, look, it had nothing to do with my client. It had nothing to do with, any sort of trouble in paradise, so to speak, because they had a volatile relationship at some point. It had to do with someone, a third party, who came in and, committed this crime. So they'll be able to make that argument if, in fact, obviously the evidence is going to show that.
Last question on this. There was a long delay before they brought charges here. And it's not like your typical, what we would call a cold case where they didn't know who was responsible. This suspect had always existed. They always knew she was the roommate. It's not like they just discovered that years later. It's just that now they felt that, obviously, for whatever reason, that they had enough evidence to now proceed to trial on it. Do you think that delay alone, though, will trouble jurors, or could be something that defense could use to their advantage? Just the mere fact that it took prosecutors this long to bring charges.
No doubt about the fact that the defense is going to use that, and it will help them. This is a very long time between the incident and when the actual arrest was made. And, now these charges are being prosecuted. You have to wonder why it took the state so long to come after her. And she was the roommate, so she's the likely suspect. She was the one who had access to the apartment. And if you can show that she, had some sort of motive, obviously you don't ever have to prove motive, then that's an easy target. And the defense is arguing that it took them a long time to get to her because she wasn't guilty. And there are other people, not just one. There's one person, this Devin Hall individual, who apparently was lurking around the apartments, and he, was seen in a video somewhere, and they're saying that it might be him, but there are other people. There's this boyfriend who was obsessed with her, at least according to the defense. And there's a maintenance man who apparently committed suicide. And right before he committed suicide, said something to the effect of, I have a heavy heart. So the defense is trying to make it seem as though, why in the world would a roommate who has, been with this individual, who is a friend to this individual, why would she do this? And even making an argument that, the way she was killed is too much for the defendant to do. Nichole Rice is, a woman and wouldn't have stabbed someone to death, and, someone of her background, making it seem as though there was no reason for her to do something like this. So I definitely think the defense is going to use the delay in their favor, and it is in their favor. If this all happened, in 2007, and now we're in 2025, and she wasn't charged until 22, it does make you think, well, where has all this evidence gone? And where were you when you got this evidence? It should not have been a cold case. This is a case where all of the evidence is sitting right there. And it's something that should have been pursued early on. And if in fact these other individuals had something to do with it, it's going to be harder, I think, for the prosecution to argue that, it was in fact Nichole Rice, because who knows now? All of that evidence is gone. They have to prove the case beyond, a reasonable doubt. And it's going to be a lot harder with less evidence.
Oh, yeah. Fascinating case. Fascinating. It's continuing to go on. Like you said, I believe their opening statements were today as we're recording this. We will continue to watch it. So hopefully they will be well into their case by the time this is released. But that is all we've got for this week. Terri, as always, it was a pleasure. And thank you so much for coming on. Where can people find out more about you and what you're up to?
They can find me at Terri D. Austin on all my social media. And I also have a website. Just Google Terri Austin.
Fantastic. And I'm your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts, and we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.